Good morning, Your Honour. Richard Penery Jones, counsel appearing on behalf of the applicant, Mr. Tucker. Your Honour, defence is seeking a pre-trial ruling pursuant to section 590AA of the Code. This is in regard to Crown evidence, specifically evidence acquired during the search of Mr. Tucker's private premises. We request for it to be excluded on the grounds of the public policy interest, as affirmed by the High Court in the case of Bunning and Cross. It is counsel's submission that the search warrant is invalid on the basis that police have not followed their proper statutory requirements under the Police Powers and Responsibilities Act. As such, the search was unlawful and all evidence acquired during the search is therefore inadmissible. Now, as per the criteria founded in Bunning and Cross, counsel seeks to prove by the civil standard that the gravity of the police officer's conduct was so grave that in the interest of public policy and the administration of criminal law, the evidence must be excluded. Your Honour, the conduct of the officers involved demonstrated a reckless disregard for the law, bordering on an abuse of power. From the application to the issuing and enforcing of the warrant, proper procedure was not followed, and in fact several statutory requirements were breached. Firstly, section 151 subsection A, which states, a search warrant can only be approved if the applicant can demonstrate on reasonable grounds that the evidence is either present at the property or is suspected on reasonable grounds to be delivered to the property within the following 72 hours. Reasonable grounds is defined by the High Court in the case of the Crown and Rocket as the existence of facts which are sufficient to induce the suspicion and belief in a reasonable person. At the time of the application, which was the 3rd of July, Detective Sergeant Anderson stated that he did not believe there were any drugs present on the property on that day of the application, but he believed that some may be delivered in about a week's time by the 10th of July, which was 7 days after the application. There was no indication that he believed or had reasonable grounds to induce the belief that it will be delivered within the next 72 hours. However, the issue was the warrant was issued on the grounds that Mr. Tucker was not only in possession of drugs on the 4th of July, but that he supplied those drugs to another person on the 4th of July. How the detective purported to know of Mr. Tucker's possession and supply on the 4th, when he himself believed there were no drugs present on the 3rd and wouldn't be any more drugs delivered for another 7 days, is confusing, bordering on inconceivable. Police are required to have an in-depth knowledge of the operation of the Police Powers and Responsibilities Act, and it is therefore counsel's belief that the sergeant was well aware of his requirements under the Act and intentionally set out the date of the offence to be within 72 hours so that he would have reasonable grounds to search the property, quote, once he expected the drugs had been delivered. Further supporting that the police had no actual belief that any offence had occurred on the 4th of July, they instead waited to search property until the 5th of July. Again, no information was provided by the police as to why they believed the drugs had now been delivered on the 5th, despite their constant surveillance of the property. However, they claimed that they began their search because they saw Mr. Tucker was returning to visit his unit, an action that does not in itself indicate any wrongdoing. The police clearly knew the warrant was due to expire under section 155 subsection 2, and in failing to apprehend Mr. Tucker, the police were fishing for evidence in an attempt to justify their claims. Now, in conducting an intensive search, the police destroyed an internal wall of Mr. Tucker's unit, this is expressly forbidden by section 150 subsection 4, as causing structural damage requires the approval of the Supreme Court, as the Magistrates Court does not have statutory power to approve this. My learned colleague may argue on the part of the Crown that they did in fact have this power under section 157 subsection 1 subsection K. However, that power only applies to the removal of the internal lining of the wall, not the destruction of the wall in its entirety. Now, inside the wall, which again the police were not permitted to search, they did find 110 grams of heroin. Defence is not disputing that it was heroin. However, we do dispute the relevance of that heroin to the offence of trafficking. Quoting Justice McPherson in the case of the Crown and LLB303, trafficking requires evidence of a commercial context. This can be, for example, advertising drug paraphernalia like scales or zip bags. And despite the officer's belief that Mr. Tucker had engaged in drug dealing and sold all the drugs by the 3rd and 4th, he didn't find any cash or any evidence of any kind of involvement with drugs outside of potentially personal use. Now, although there are no exact quantities that are a determination of trafficking, 110 grams with no added paraphernalia attached to it does not indicate any kind of commercial context, and it doesn't indicate supply as a matter. Now, I compare this case to the case of the Crown and Day and Davis, where police seized 500 grams of cocaine, 18 MDMA caps, 6 mobile phones, $11,000 in cash, a laptop, a money counter, and smoking utensils. The Supreme Court ruled the evidence as inadmissible as the search was conducted unlawfully. Comparatively, police in this instance committed a similar level of impropriety as the police in that case. However, in this instance, they only found a small amount of heroin inside Mr. Tucker's wall. A wall which, again, they did not have proper approval to search. Following the investigation, police again breached statutory duty as they failed to provide Mr. Tucker with a copy of the search warrant pursuant to their requirements under Section 158, Subsection 1, Subsection B. In totality, Your Honour, that constitutes 5 breaches over a period of 3 days, and that was in combating what amounts to no more than a mere drug charge. Your Honour, I quote High Court Justice Stephen Aiken in the case of Bunning and Cross. It is not fair play that is called into question, but rather society's right to insist that those who enforce the law themselves respect it, so that a citizen's precious right to immunity from arbitrary and unlawful intrusion into the daily affairs of private life may remain unimpaired. Mr. Tucker returned to his shed to find his door forcefully opened, his walls destroyed, and his favourite movie stolen, all as a result of an invalid warrant with no legal basis. My learned colleague will try and argue on behalf of the Crown that despite some mistakes made by the police, they did still find the dangerous drug in Mr. Tucker's possession. In response, I again quote Justice Stephen Aiken, "To treat cognitive evidence as a factor favouring admission may serve to foster the quite erroneous view that if such evidence be but damning enough that it will itself suffice to atone for the illegality involved in acquiring it, the idea that the result is more important than the method. It's a dangerous precedent when such a blatant disregard for the law has been used to combat such a minor drug charge. I do not think that this benefits public policy, Your Honour, and that is the end of the Council's submission."